Kwa sababu sisi wazee hata kama wengi hawajasoma, lakini wana miaka mingi hapa, wameona mengi.
In 2010, with the emergence of the new constitution, where we really contributed to Article 159 of the Constitution that speaks about traditional justice systems, use of mediation, and alternative dispute resolution mechanisms. And we had to ask ourselves, how do we then breathe life into this particular Article 159 to ensure that the common mwananchi is able to access justice? So in that particular process, and partnering with like-minded institutions, that is the Judiciary Training Institute, local civil society organizations, and community-based organizations, we did start a process of thinking about a task force that is supposed to deliver policy guidelines on alternative justice systems.
In particularly to this task force, the processes that were adopted to carry out the research to develop the policy, we applied a multi-pronged, multi-sectoral and multi-pronged processes. So the process started first with Professor Ngugi, Justice Kiara Kariuki, by then he was a Court of Appeal judge and Director JTI, Dr. Steve Ouma Akoth, and the former Chief Justice, Dr. Willie Mutunga, had an intellectual discussion about the intention and purpose of Article 159, Sub-Article 2C of the Constitution 2010, Kenya.
It wasn't easy. First, we had conversations on what to call it. I remember back then, we debated for a whole year whether we wanted it called multiple justice system because it involves mediation, conciliation, ADR, or do we want to call it informal justice system? And with all the balancing, we settled down on alternative justice systems. Alternative to what? Alternative to the formal justice system. Why? Because we want to see a system that is expeditious, that between me and you, or two disputing parties, we can sit down with an arbiter in between or a mediator in between, probably elders who can also guide us in a way, the way our community works, whether it is in Jorinjake in Meru, whether it is in Taita, where we have got the Wazes there, but also that is affordable.
Therefore, arising from this discussion, a move was taken by the Honorable Chief Justice, said, okay, we'll appoint a task force. So upon appointing a task force, the task force began its processes by looking at how to go about. So the first step was to invite councils of elders to have a dialogue, to have a discussion. And in this discussion, what came out clearly is that the Council of Elders wanted to elaborate more on the modus operandi, how they operated in resolving disputes using these alternative dispute resolution, basically the traditional dispute resolution mechanisms. The other thing which came out from this discussion is that the old men these elders were grappling with what alternative is. So at the end of the day, they were saying, yes, the formal justice system is more of alternative to the traditional dispute resolution mechanism. Because they were saying apply these systems in far-flung areas of this country, in areas where the courts do not exist. So when you say traditional dispute resolution mechanism is alternative, they would say alternative to what? We use, so it is alternative to ours. Then from there, the task force invited a group of academicians and civil society luminaries to discuss this issue. And upon discussing this, what came out is that there was need now to go out there to know what's happening.
And I again will go back to around 2012, 2013, we had developed guidelines for traditional justice systems, so which again also come in terms of determining how such systems are going to implement the policy. And there are 4 models that are identified. One is the autonomous AJS. There's the autonomous third-party AJS system. Then there's a court-annexed AJS. And lastly, what is called regulated AJS system. But when you look at the document, it makes proposals for 3 models. One is the autonomous. So the autonomous is basically those systems that are not state regulated. They are out there in the communities, and people use the traditional laws and community customs, and some of those what you'd call cumulatively what the community has come to appreciate as their law. So that is what works in the autonomous systems. In most cases, you find elders who sit under a tree, elders who sometimes will meet in a public place, say a chief's office, a hall next to it, but not necessarily under the chief. But they are autonomous and make decisions in that manner. The third-party autonomous system is what you find in institutions. A good example would be if you go to like the National Commission on Human Rights, there will be a sort of a dispute resolution desk. And if you go to a chief's office, the chief is is part of the state organs because it's the office of the president, it's an executive function. And then you will find this, so in the chief's office, you go to DC, you go to, the ward administrators who are in the county government. So all these levels, you find a dispute resolution system. So it is not quite regulated by the state, but it is sort of appreciated by the state. So, and it is state officers. But you'll also find the same in the non-state institutions. A good example would be if you go to FIDA, they will have a mediation platform. You go to Legal Resources Foundation, you have 2 people in a dispute, they will provide an opportunity for dispute resolution. That is the third party. It's sort of not really written in law, but recognized by the state as an opportunity for filtering some of the cases that come to the courts. And then, so what the third one that the policy recommends is the court-annexed AJS. The court-annexed is, as the term goes, annexed to a court. So, and the way it is formed, a court user committee in the locality sits and makes a determination that we need to start a court-annexed system. And we will have elders, we will have, say, the probation department, we will have officials from some of the government institutions, and the elders, they sit together to resolve disputes. So in this case, you will find that they use both what you could refer as modern law and the traditional laws to resolve disputes that are referred to them by the courts.
Despite the fact that we now have a policy in place which is yet to be operationalized, there are a myriad of challenges that are outside there. One is that the mere reception of the policy guiding the application of alternative justice system, that reception alone is not enough. We need to sensitize and popularize the same. There is a lot of work to be done to show the people, the grassroots, that there is already a policy guiding your operations, so that now they can be brought on board.
The policy has a number of strategic interventions, and for us as an institution, we are looking at these as areas that require further working or further collaboration and further input from the different actors, both the government and the non-state agencies. And looking at the policy, the first strategic intervention speaks to actualizing the policy itself, and this means we need to have the AJS system formally recognized. So it's looking at probably work towards having the 3 models that we've spoken about becoming institutionalized and recognized. So probably have a gazette notice to institutionalize these 3 models and give them power to continue or start working. Then the other thing is also recognize that these AJS forums can be courts of first instance, where people can go, and if they're not happy about whatever verdict that comes out of the forums, then they can be able to appeal at the court now, at the formal justice system, through monism. We're having standard operating procedures. So that is an area that probably needs to be worked on. That is an area that institutions like Legal Resource Foundation and other organizations that are into AJS work can contribute towards that development. Because once we have a standard operating procedure for the elders, then they'll be able to be guided to ensure that, you know, this is how they are going to be appointed, these are how they're going to operate, these are the ethics that they're supposed to meet, and of course, if at all they violate this, then this is how they're supposed to be removed from the AJS practitioners, either database or just working processes. Then of course, having a sitting or probably an institution that will be able to ensure there's coordination of these elders, because right now there's none. And of course, who coordinates, who is able to check that these people are doing the right thing, these elders are doing the right things, the practitioners are adhering to what is expected of them. So having a committee or a formation that will help us monitor and of course criticize or question whatever processes these practitioners are doing, and of course give directions whether they are doing it rightly or not, and of course just regulate what these AJS practitioners are doing. The third strategic intervention is basically on trying to come up with best practices of how this AJS can work, and of course ensure that in as much as they give the first instance justice, then of course they're also in line with the Constitution, and of course they're not picking cultural practices that may end up offending the Constitution and of course the main purpose for which they were initially developed for or recognized for. The policy is very clear that even at the AJS platforms, people who are either presented before them have a right to be represented. So when that happens, who is supposed to go there? What level of persons can represent any person at the AJS platforms or AJS mechanisms? So the policy proposes intermediaries, and this is very good because it's giving life to the Article 57 of the Constitution that speaks to intermediaries. So intermediaries are people who can come to court according to that section of the article of the Constitution and help someone communicate with the court, or now under this formation, the alternative justice mechanisms. So under that, we want to see, probably identify who are going, these people who are going to be called the intermediaries. How are they supposed to operate themselves or probably interact with these mechanisms? So by giving life to that article, I believe the policy is very clear. And of course, that is one of the areas probably that will now see more of Article 57 of the Constitution taking place and of course being actualized even as people get represented at the AJS mechanisms. And of course, we are looking at paralegals because LRF works with paralegals. Then how are these paralegals going to help people who are accessing justice under the AJS mechanisms? And of course, facilitating that process so that they are able to navigate that process from an informed perspective, and of course get the necessary legal advice that they need to be able to get justice even as they go through the processes. The last strategic intervention speaks to strengthened and sustainable resource mobilization. And under this, basically the policy speaks to financing AJS mechanisms in the country. And of course, because it is now an added function under the justice sector, then it needs funds because there are so many things that requires money. And of course, looking at probably funding the salaries, probably, that is my thinking around what the resource mobilization speaks to. And the policy suggests that we need to have a targeted budget for AJS mechanism so that the government now needs to be moved. And of course, now all of us need to advocate for a targeted kitty that will support AJS work in the country, because they'll be contributing to addressing disputes or solving disputes in the justice sector. And of course, that is work and probably needs support, some form of, remuneration. So that is one element that the policy is proposing. But the core one that I'm also seeing, considering that somehow the country might not be able, or the government might not be able to really completely finance the AJS, even as we await for that, because that is a different process, what can the non-state organizations like Legal Resource Foundation do to ensure that these organizations, these AJS platforms that we have in the communities, are able to self-sustain themselves? And I think LRF has tried to do something. In Isiolo, we have purchased 5 motorbikes, and in Isiolo we have 5 communities, 5 councils of elders. So each council of elders was given a motorbike, and we believe that if this motorbike is put in well use or good use, then they're able to get resources to help themselves navigate the terrains, of course, and of course even get something small that they can be able to use to facilitate their airtime, probably water to drink, even as they address this or resolve these disputes, and of course even get stationaries, because those are the things that probably AJS practitioners will be looking for.
What the implementation committee may need to do or may have to do is for schools. We have students going through university education in the law programs, so they will need to appreciate alternative justice systems in their curriculum, so that you don't just have law graduates who get to interact with alternative justice systems when they graduate. We want them to, as an institution, we would want them to interact with these systems very early. And I think this also goes to other social science programs. Interact with the AJS early enough, so that then we built a critical mass of Kenyans who appreciate AJS, that one as a way of life, two as a way of easily resolving very many disputes.
Diakonia has supported much of the LRF's work on the alternative justice system work, and we've been with them for more than 10 years. But currently we're implementing the second phase of a 5-year program. So, and the second phase is almost also coming to an end. We'll be ending the project next year, June. So this program, Democracy, Governance and Human Rights Program, is being implemented by 15 partners. And Legal Resource Foundation Trust is one of the organizations that implements access to justice issues. So under this program for LRF, we do work with the different actors. We have the judiciary forming part of the partners we're working with. We're working with the prisons. We're working with the police. We're working with the ODPP. And the work that we're doing here majorly is, first of all, monitoring how the Constitution, and especially Article 49 of the Constitution, applies with the minimum standards with regards to access to justice. So that is one component, ensuring that we have the minimum standards on access to justice are respected by all actors working in the justice system. The other element is that we also monitor human rights within the prison facilities and the police stations. So under that, we train a lot. We use the standard minimum rules, which is somehow called also Mandela rules, that we use to monitor work in prisons. So we train prison officers at that level, and they're able to now form committees after the training, and these committees have monthly sittings where they're able to sit, analyze their issues within the prison and just bring out those elements. How are they able to like comply to the minimum standards that are provided by this international instrument on treatment of persons in detention? So that is another component that we work on. And also another major work under the program is the alternative justice systems. So the project has also supported that work, and it has really given us great milestones. And I believe even as we discuss what the project has done for this work, we can say Democracy, Governance and Human Rights Program has really given much in terms of funding. We do a lot of training, we do a lot of public sensitization so that people appreciate what are these laws, what is expected of them, what is their role, even as they demand or seek justice in wherever sectors they go to. So this project basically helps us to do that. Then we also do advocacy. And the AJS policy falls under that component, because advocacy majorly for us is lobbying and pushing for different structural, it can be legal, could be structural reforms, it could be policy reforms, and that is where now our policy, the AJS policy, falls in. So under this program funded by Diakonia, the Swedish Embassy through Diakonia, we're able to push for the alternative justice system policy. And initially the work that we had commenced prior, with the support of Diakonia, we developed guidelines, traditional dispute resolution mechanism guidelines. But even as when the government realized that this is good work and probably needs to be institutionalized, they felt the guidelines that we had developed earlier could form a bigger picture. And instead of just focusing on the traditional dispute resolution mechanisms, they decided to have it called alternative justice systems so that it captures broadly. So that is also work that we celebrate having funded through this program that we are getting from Diakonia through the Swedish Embassy.
Diakonia is a Swedish faith-based development organization rooted into Christian denomination in Sweden, that is Swedish Alliance Mission and Uniting Church in Sweden. We were established in 1966, and we operate in 4 regions in the world. We work with around 400 partners in 25 countries. Our mission is to change unfair structures, that is political, economic and socio-cultural structures that generate violence, poverty, oppression and inequality. Our vision is a just, equal and a sustainable world. In our Kenya country office, we manage 2 programs, or we have 2 programs. That is democracy, governance and human rights, and socio-economic justice. Our work on access to justice is anchored in our democracy, governance and human rights program, where we are supported by the Embassy of Sweden. We are working with 15 partners. We have partners working on governance and accountability, and partners working on access to justice, meaning that they work with institutions in administration of justice or the criminal justice system. The AJS work, we work with 2 partners, that is FIDA, or Federation of Women Lawyers in Kenya, and Legal Resources Foundation. And the AJS journey started a long time ago during the phase 1 of our democracy, governance and human rights work, which came to an end in 2018. What I can say, it has been a long journey, but very consultative, very engaging, and we are happy with the progress now that we have the policy. A policy that is informed by voices from the community level, those who are practicing alternative justice work or traditional dispute resolution and all other means in terms of not formal but in the informal way. So we are happy that the elders who are doing that work have done great work in terms of informing the policy.
I also wish to thank the Swedish Embassy through Diakonia, the key partners, our big brother in Kericho. I think LRF has really done a tremendous job. Not for them, we would not have achieved what we've achieved. We have good relationship with the courts, Kericho courts, where we've worked with the courts. The courts are able, we've linked the elders with the courts, whereby most of the cases are being referred back to the elders. We've also brought the elders on board. They sit in the court choosers committee, where they can be able to raise the challenges they face, the successes, and also even the Kericho was part of the pilot project. Even when the task force went round, and we must appreciate also the then chair of the AJS, Justice Ngugi, who came to Kericho, interviewed the elders, and was so impressed by the work of what the elders are doing in Kericho. I think I believe that with this support, we will continue in future with the same partners.